Hey everybody, this is John Skiba with the Arizona Consumer Law Group, and in today's video I'm going to show you how to make appropriate objections in your debt collection lawsuit. But if this is your first time to my YouTube channel, go ahead and click subscribe and click on the little bell there. That way you won't miss out on any of the new content that I put out each and every week. Okay, let's talk about objections in a debt collection lawsuit. Now, this is going to be specifically geared towards people who are being sued by junk debt buyers. Junk debt buyers are not the original creditor. They are entities that are alleging that they purchased your debt and now they're trying to sue you for it. They usually pay pennies on the dollar for it. The studies show it's usually less than 4 or 5 cents on the dollar. I've even seen cases where they paid less than a penny on the dollar for the debt that they're suing you on. Their whole goal is to get a judgment against you so that they can then garnish your wages or take money out of your checking account. Now, you have some good defenses to a junk debt buyer when they file a lawsuit against you. After all, they didn't loan you any money. You didn't agree to pay them any money. And so they've got to come in and show not only that you had the original account, what the balance was, that you didn't pay the balance, they also then have to show that they are the actual owners of the account. And because they pay so little for these accounts, they don't get a whole lot of documentation and they don't have witnesses coming in to testify from the original creditor. And so the issue that we have when we're looking at raising objections to their evidence is very important, because if you can raise appropriate objections to their evidence, you have a good chance of getting their case thrown out and you winning your case. Before we dive into the specific objections, the thing you have to remember is that it's on the plaintiff, it's on the debt buyer, it's on the Midland Fundings, the portfolio recoveries, the Cavalry SPVs of the world. They have to prove all of these elements. You don't have to disprove them. So if you can object to their evidence and get their evidence so that it's not admitted into court, then you have a much higher likelihood of winning your case. Now, there are a lot of objections in general when you're litigating in court. I'm going to focus on one specifically that relates to debt buyer cases, and that is hearsay. Now, hearsay is any written or oral statement that happens outside of the courtroom from another party. So, for instance, if I'm testifying in a court hearing and someone asks me, "Hey, what did your neighbor tell you about whatever happened?" That would be hearsay, because they don't want to. It shouldn't be what I'm saying my neighbor said. We should have my neighbor come in and be able to testify about it, not just what I heard my neighbor say. Well, the same applies to documentation. When documents are admitted into evidence in a junk debt buyer case, they're usually documents that were created by other companies. Let's say you're being sued by Midland Funding and that they have documents from Chase Bank. Essentially, what Midland Funding is doing is they're often trying to bring these Chase documents or the Wells Fargo documents or whoever the original creditor is, and trying to have those admitted to the court without doing what's called laying foundation or authenticating the document, because they don't have a witness from the original creditor. They don't have someone there to testify as to how these documents were made and prepared and stored and even how they got them. And so if you find yourself in a situation where they're trying to introduce documents, and this happens really in two possible places in your case. First is with a motion for summary judgment, where they're submitting a formal written brief to the court trying to say, "Hey, Judge, we don't need a trial. Just look at our evidence and tell us we win." You can raise objections to their evidence at that point. Or if you're in an actual trial setting where they're trying to give documents of the original creditor to the court to review, you can object to those documents coming in at that point. Now, the appropriate objection is hearsay. However, there is some exceptions to the hearsay rule in the rules of evidence. Now, every state in the federal legal system, they have what are called the rules of evidence. And it's usually fairly simple. Like there's the federal rules of evidence, there's the Arizona rules of evidence, and they're all pretty much the same. They kind of have little tweaks here and there. And conveniently, they're mostly, in most states, they actually number them the same as the federal rule. So the rule that I want to talk to you about today is Rule 803, subsection 6. This is known as the business records exception to the hearsay rule. So what this rule says is that under certain circumstances, if the person who's offering the document into evidence can show certain pieces of information, then those documents can be admitted into evidence and they're not going to be considered hearsay. However, debt buyers really struggle with this because, again, they don't have the personal knowledge to be able to testify it. So let's look specifically at what the 803.6 requires. So when we look at 8036, it says records of a regularly conducted activity. And this is the federal rule that I'm reading from, but like I said, most state rules will be similar. So the record, the business record or the document can come into evidence if a witness can show, subsection A, that the record was made at or near the time by or from information transmitted by someone with knowledge. So basically they're saying that we have to be able to show, or they have to be able to show, the debt buyer has to be able to show that that business record, that that monthly credit card statement was made at or near the time that they're purporting that it actually was put together or sent out. Subsection B, that the record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. So essentially they have to show how the document was stored. How did they keep it? How was it transmitted? Where after they created it, where did it go? Subsection C, they have to show that making the record was a regular practice of that activity. So, for instance, they would have to be able to testify that Wells Fargo, this is normally how they made the monthly statements, or this is how they made the terms and conditions that they're sending out. And then subsection D, it says all of these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 902.11. We don't need to worry about that. So essentially what subsection D states is that all of those elements that we just went over, it has to be attested to by someone who has knowledge. They have to be a qualified witness. This is a difficult one for the debt buyer because I can tell you, when I cross-examine a debt buyer's witness, one of the first things I ask him is, did you receive any training from the original creditor? Let's say the original creditor is Wells Fargo. I'll ask him, have you ever worked at Wells Fargo? Have you ever received any training from Wells Fargo as far as how they keep and make and maintain their records? And the answer is always no. They don't have any information. And then the last subsection, subsection E of 8036, states that essentially that there's no indication of a lack of trustworthiness. You can also attack documents based on the fact that most of the debt buyer documents are highly redacted. Often in the bill of sale and assignment, you'll see that it will say that all the documents or the accounts are listed on Exhibit A. There is no Exhibit A. Or one of my favorites, it'll be like Exhibit 1. It'll be totally mislabeled because they're just kind of throwing this thing together, even making it after the fact. So the way to properly make the objection, whether it be in summary judgment, where you would be doing it in writing, or if you're in trial, is to tell the court, is to go through these requirements of 8036 and say, look, there's all these requirements. They have to testify about how the record was made. They have to testify how the record was kept. They have to testify whether making that record was a regular activity of the business. And then you can really drill down on subsection D, where the witness has to be shown to be qualified to be able to testify to that. I can't be called to testify as far as how Walmart keeps and maintains their business records. I don't work there. I never have. I've never received any training on that. So my testimony it would be hearsay. There'd be no foundation to it. There'd be no basis for it. That's what you have with debt buyers when you get into trial, is that their witnesses, whether it's in an affidavit. Often you'll see they'll submit an affidavit with documents, and they'll often say, to the best of my knowledge, these documents were created at the time of the underlying event. They have no idea. And in trial, whether they're over the telephone or in person, same thing. You can object to their testimony because it doesn't meet that standard of 8036. Now, let me give you, and I should say this, if you can object to that and get it sustained in trial, or if the court agrees and doesn't consider the evidence, game over. The monthly statements don't come in, the terms and conditions don't come in, the bill of sale may not even come in, just because it's not trustworthy in that it's missing a lot of the information that you need. So if you do that, the case is over. You're going to win your case because they're just simply not even going to have evidence to proceed on that. Now, one little asterisk, in states like Arizona and some federal courts, there's a minority of cases or courts across the country, different states, that allow for what's called this rule of incorporation, where essentially if the debt buyer can come in and show that the business records that they received were incorporated into their records, then they are going to allow the debt buyer's witness to be able to authenticate, lay foundation, and testify about documents, even though they didn't have any role in creating them, storing them, they don't have any knowledge, they still allow them to do that. I think it's a horrible rule. And there's just a few states that follow it. Unfortunately, I live in one of them, Arizona, where the courts will follow this rule of incorporation. The only bit of advice I can give you on those is that they must show that the documents were incorporated into their business records. So that's a question I always ask them. When did that happen? And what you'll often find is that debt buyers, when they actually buy these big portfolios of cases, they get very little documentation. And often the documents that they get, they had to go back and request after they filed the lawsuit, and then they bring them in for the purposes of litigation. And documents that they went out and got for litigation are generally not considered business records. If they weren't incorporated into the debt buyer's records, if Wells Fargo didn't actually send all the monthly statements and everything at the time they bought it, a few years prior, then you can attack it that way because they were not incorporated at the time of sale. They were just obtained for purposes of the court case, and you can raise the objection. And most courts should sustain that because that's a big problem. So I know that can get a little bit complex, but it's something where if you really go through the requirements and think about it, you've got to have a person who's qualified and understands how the original creditor made and kept and stored their documents. And the debt buyers don't have that. They have someone who has no information about all those things. So if you appropriately raise that objection, either in writing in summary judgment or during the trial, then you should be successful in getting those thrown out. If you want to learn more tips about how to defend yourself in a junk debt buyer lawsuit, check out some of the other videos I have here on my YouTube channel. I have a lot that will walk you step by step how to do that. Thanks for watching today.